Greetings and welcome to the Fourth International Conference on International Law and Legal Policy, November 2025. I am Mohamed Arafa, law professor at Alexandria University Faculty of Law in Egypt and the visiting faculty at Cornell University School of Law in Ithaca, New York. Thank you very much for joining us at this important international conference, specifically for this year, as we facing a lot of international challenges around the world. So leading academic scientists, researchers, and scholars in the field of international law, international relations, political science, legal policy, and sociology come together to the fourth edition of this international conference to share and exchange experiences and research findings. In addition to that, this conference will offer a top-notch multidisciplinary forum where scholars, professionals, and educators can showcase and converse about the new advancements, issues, and trends, as well as real-world difficulties that faced and overcome. So at this point, it is very important that we have this gathering in November to discuss what we are facing from various conflicts around the world, from Russia, Ukraine, in Eastern Europe, in addition to Gaza and Hamas, Israel, Palestine within the Middle East, to climate change, to a big and massive change within the U.S. foreign policy since President Donald Trump returned to the White House. And there are a lot of legal and political consequences, specifically after the outcome of the 2024 presidential elections in the United States. So at this point, I would love to talk to you today about a kind of an interesting topic, which is also facing a lot of challenges within the international law and international relations, which is also a very interesting topic that I will be having for my upcoming book that coming out by the end of 2026 by Springer Publishing House, which is a co-authored book with my friend, Professor Anthony Abbott Nant. And he is a professor of law at the University of Copenhagen in Denmark. And we are working on what we call transitional justice and systemic racism. So our book is discussing that concept of transitional justice and its relationship or connection to what we call also systemic racism. And I think this is very important at this point. Specifically, we try to delve in and dive within comparative analysis of the things and the events that have been taking place in Eastern Europe, specifically the Balkans area, the Arab Spring events, and what have been done or have been achieved when it comes to transitional justice and moving towards democracy within the Middle East, specifically in countries like Egypt, Tunisia, and recently we do have Syria as well. So I think this is a very critical moment, and it is important to discuss this point. I have been working before on transitional justice, and I have been published about it, but this is, I think, my first time to delve in for much more within a bigger project, and I am very interested to hear from you to get a great feedback and great feedback from scholars, rule of law practitioners, political scientists, and journalists, reporters, activists, and all of that, because this is very interesting at this point when it comes to the concept of transitional justice and also the concept of what we call systemic racism as well. So when it comes to the point and the definition of transitional justice, and we're dealing with this, so we ask ourselves a simple question: what is transitional justice? And mostly I'm going to say that transitional justice mostly refers to the set of judicial and non-judicial measures that have been implemented by different and various countries in order to redress and highlight the legacies of massive human rights abuses in transition. In other words, that we are tracking the accountability of the regimes that they have been falling down and making sure that the abuses of the human rights of the people that they got the victims to be for these abuses or violations have to be punished and to be held accountable to the fullest extent of the law. So I think this is a very interesting, important discussion when it comes to the definition of transitional justice, which means also that we do have kind of what we call goals when it comes to transitional justice, because we're addressing a kind of a transitional period, and we wanted to make sure that the leader or the people that have been in office or served in the government at this period of time, if they committed abuses or violations for human rights, should be held accountable to the fullest extent of the law. So if we are trying to say what are the goals of transitional justice, one of the main thing is very important when it comes to that. We'll realize that restoring public trust. In other words, that public citizens or the general public wanted to make sure that their government is acting on their behalf, that guaranteeing transparency, that guaranteeing integrity, that guaranteeing due process, making sure that the institution of the government is working in a very objective way. And this is what we can see at this point, that there is a kind of a big shift within the Trump administration about the respectability of the rule of law. So restoring public trust, meaning that we have to establish the respectability for the rule of law. One of the other thing also that we have to make sure, as represents one of the main goals of transition and justice, is ensuring that the vulnerable communities or the vulnerable victims of the human rights abuses or violations have equal access to justice, especially if the conflict cut across this cleavage. In other words, that we have to make sure that the victims and their families will be compensated in a way or another, and that the perpetrator of any abuses or violation that have been committed or that have been done by people in office at this specific period of time shall not escape impunity, shall receive the punishment and hold accountable to the fullest extent and to the fullest extent or a maximum of the law. Meaning that we have to make sure that we are building accountable institution, meaning Congress or the legislature, of course, independent judiciary, and a totally non-political criminal justice system. In other words, that we do not have to examine or to experience that the judiciary would be a kind of politicized, meaning, in other words, that if the regime tried to politicize or use the judiciary to serve their personal interest, instead of serving the general public, instead of achieving justice, and instead of upholding the rule of law and order. In addition to that, we have to make sure that we are also addressing the underlying causes of the conflict. For example, what we see right now in Russia, Ukraine, Israel, Palestine, we have to make sure that there are main causes for these conflicts that are taking place around us, and we got to make sure how we will be able to solve the problems for these conflicts. In one way that we can ask ourselves, which represents, of course, one of the mechanisms or the measures of transitional justice, is seeking post-conflict reconciliation. Reconciliation represents one of the main mechanisms. Of course, it includes what we call the politics of memory, which means that we have to compensate and making sure that the families and the victims that they have been totally abused under the transitional period, that that they have been compensated in a well shape. And that's, of course, will guarantee restoring the public trust. We got to make sure that we need to facilitate a sustainable and robust peace process as well. This is very important at this point. Make sure also that it is important to create a role for women and other marginalized groups in the transitional justice and restoration process. In other words, we have to make sure that we can afford like a kind of what we call protection for witnesses, journalists, reporters when they are doing their jobs and reporting about very sensitive cases when it comes to transitional justice and different conflicts. So this is important. This is why when it comes to the how transitional justice is very significant at this point, and when it comes to that, one of the scholars and justices actually have been defining transnational law, which is totally connected to transitional justice, as all law which regulates actions or events that transit national frontiers, and that's for sure will be including public international law, which when we're talking about the sovereignty of the countries, when we're talking about diplomatic relations, and of course, the private international law, which mostly when we're talking about immigration, when we're talking about nationality and citizenship act, when we talk about this. So, and this is for sure will not going to be related to the human rights issues when it comes to the transitional justice, because transnational law, we sometimes call it global law. It's the law that operates in the gap between states or countries. It includes rules created by multinational corporations, for example. It could be like by global industries. So it is often a kind of intertwined between what we call domestic or national law and international law. So it is very important to make sure that when we deal with transnational law is a kind of a law that involved in many of the world biggest and strongest challenges as we face at this moment. The violations of human rights as we see, specifically when it comes to the various conflicts that we are facing, Russia, Ukraine, Israel, Palestine, India, Pakistan, and others, climate change. So transnational law is a broad concept that includes one of the main things that when we're talking about international and comparative law, uh, you will see that scholars like Professor Ruti Tettel define transitional justice as a conception of justice associated with periods of political change, characterized by legal responses to confront the wrongdoings of repressive predecessor regimes, which mean that we have to make sure that, in other words, that it is a concept of justice has evolved to summarize debates on how successor regimes should address human rights abuses that committed by authoritarian regimes or by dictator. So this is why we wanted to say if we have a concept called a systemic justice, which works radically transform how the law works for community, fighting for social, racial, and economic justice. Meaning, in other words, that systemic justice works to broaden access to judicial remedy and fight for justice and equality, which is very important when we deal at this point with this. And that means that also here, that we do have legal sorts of transitional justice when it comes to what we call retributive justice, which means that in the aftermath of a violent conflict, establish minimal justice through the rule of law is one of the most important elements in building stable peace. And we do have the restorative justice seeks to address the issue of human rights violations committed during period of conflict based on a different logic. And this is mostly, as I mentioned, related to what we call post-conflict justice. But we do also have the pre-conflict justice, which is mostly related to the distributive justice. And distributive justice here mostly seeks to tackle the roots of the unrest by addressing the structural factors that led to the escalation of conflict to violence. And we saw these post-conflict justice mechanisms like the truth commissions, the war crimes tribunals, and the reparation programs that have emerged as a fundamental building block of durable peace settlements, or in, for example, Latin America, in Africa, in Asia, and recently in the Middle East after what I call the failed Arab Spring. So here, when we're talking about examples of this systemic racism, which I try to connect and with Tony, my co-author, try to address, it's very interesting to look at the examples of this systemic racism when it comes specifically to Middle Eastern countries that they have been under colonialism for a while by the Europeans, the British, and the French. For example, that they have been colonized Tunisia, Lebanon, Egypt, Morocco. So we will see that, for example, the colonial favoritism, colonial power like the British and the French implemented policies favoring specific groups. For example, the French, tried to privilege the Marionette Christians or the Maronite Christians in Lebanon, which of course contributed to lasting sectarian tensions. And I saw that a lot in 2021 when I was visiting in Lebanon and I spent a year there working. Actually, I was working on one of the interesting parts or the interesting project that a book that I have the privilege of editing, which was like called Perception and Misconceptions of Donald Trump. And that was actually came out by the end of the first term of the Trump administration. In addition to that, we do have another example when it comes to the Kurdish communities in Iraq, in Turkey, in Iran, in Syria, same as the Shia communities for sure. We'll see that there is a kind of sectarian divisions between Sunnis and Shias, and we saw that in Iraq. Of course, we can see the Kurds that in post-World War I, that we have to see the marginalization in Iraq and this other communities that we can see when it comes to systemic racism. So when we're talking about today, how we can address systemic racism today, and we look at the legacies of these colonial practices, it's kind of an evident in contemporary systemic racism. We'll see that there is kind of problems when it comes to social inequality, and that's for sure, as I mentioned before, comes when it comes to the ethnic and religious minorities. Specific groups try to continue to experience these social and economic disadvantages compared to the dominant group. For example, if we can cite the Coptic Christians in Egypt have faced discrimination in various sectors. For example, the military, education, access to jobs or high employment jobs. In addition to social inequality, we do have also the political exclusion and educational disparities. Political exclusion means that there are many marginalized groups lack political representation. And we saw that, for example, in Lebanon. You'll see that the confessional system or the political power for sure is totally based or distributed based on sectarian lines. That came also along with the educational disparities. Mostly educational system at some point established during colonial rule often excluded local histories and languages and others. So you will see that at some point when it comes to how we look at the problem of systemic racism today. One of the main questions that I also am trying to address in the book, a question of if we do have a concept of transitional justice within the Islamic legal system. I did work on that before, but this time I'm trying to also examine that in a way that we need to make sure that whether there are any fundamental incompatibilities between Islamic or Sharia law and the related text and established international law, or what we call the Western concept of post-conflict justice. I'm trying to deep much more here and look at the scholarly literature, if there is a compatibility or not when it comes to that, because you will see that the transitional justice institution mostly will determine whether it will take a restorative or retributive approach. And that's very important, because here, when it comes to the distinction between restorative and retributive, you will see that restorative justice is more concerned with peace building through reconciliation between the victim, the perpetrator, and the society. And of course, healing the wounds suffered by the victims through reparations. But when we're talking about retributive justice, we're talking about accountability through punishment of individual or perpetrators, which means that it's this approach, or this retributive approach, always call for punitive measures directed at the perpetrator himself. In addition to that, we do have the hybrid process, and we saw that, for example, when the United Nations established the ICTY, the International Criminal Tribunal, to prosecute human rights violators for their crimes within the former Yugoslavia, former Rwanda as well. So that had been a kind of an interesting discussion when it comes for sure to transitional justice. I think it's important as well when it comes to that to make sure that there is a kind of the intersection of transitional justice and systemic racism. When it comes again to the mechanism of transitional justice, we do have the truth commissions, which mostly establish narrative of past abuses and address racism and discrimination, try to create a platforms for marginalized voices, documenting the systemic abuses, promotes the acknowledgement, and make sure that there is a kind of accountability that will be held to the fullest extent of the law. In addition to that, we do also have the reparation programs, which mostly is the central component of transitional justice, aimed at addressing historical and racial injustice, which at some point include financial compensation, land restitution, could be also including like we call the politics of memories, public apologies, etc. And that's for sure. We have to identify that at some point, or to some extent, you will see that acknowledging harm or offerings redress for groups historically mostly subjected to systemic racism, that at some point dismantle the economic inequalities that rooted within the kind of discriminatory policies at some point. Judicial mechanisms, mostly as I mentioned before, when it comes to what we call courts, tribunals, criminal tribunals typically emphasize the individual accountability, prosecute those who responsible for policies that enabling racial violence and discrimination, of course, reinforce power dynamics, especially if the judicial system have history of bias or complicity in a systemic racism. Civil society and grassroots movement, this is very important when it comes to how they play a very fundamental role and a crucial role in challenging systemic racism and advocating for expanded transitional justice frameworks, specifically in the Middle East, when we're talking about the grassroots movement that highlight social injustices, advocating for minorities' rights by using arts, culture, public protests or demonstrations in community forums to bring visibility to neglected issues. And we saw that in a case of Yemen recently, when the Yemenis artists and youth activists tried to foster dialogue around social injustices. One of the other things also that it's very important when it comes to the mechanisms of transitional justice is institutional reforms. We got to make sure that we do have a good institution, objective institution, either it's in the security apparatuses or law enforcement agencies, national security agencies, the military, in addition to the judiciary. These are very important and critical institutions that they already took an oath to the Constitution, not to a man or not to a person. So they took an oath to the Constitution to uphold the rule of law and to make sure that the rule of law is always respected, and that any wrongdoing that have been committed should be facing liability. There is also kind of discussion when it comes to that at some point, when it comes to the discussion on what we call the discussion and debate on human rights and Islamic law. You will see that the common foundations here, that both Islamic law and universal human rights aim to uphold human dignity, justice, equality, and freedoms. However, there is a kind of scholars, or some scholars argue, that conflicts arise due to misrepresentation rather than inherent contradictions. So there are arguments of compatibility, which mean that Islamic law and human rights share a common orientation in protecting human dignity, dialogue, mutual understanding, making sure how we will be able to interpret Sharia law or the Quranic text or the Prophet Muhammad teachings, how they will work, how the interpretation is taking place, meaning that we have to emphasize human rights protection and welfare for all. And this is how the Quranic text and the Prophet teachings have been all about at this point. And I think one of the good case studies in here to address that kind of compatibility is Indonesia. They try to say that Islamic law and human rights are complementing each other, and they argued that any perceived conflicts are due to external misrepresentations and misunderstanding. And this perspective promotes an inclusive application of the Islamic norms. You will see also the traditional, or what we call the classical view, which mostly see that the classical view, meaning that Islamic law is unchangeable and divinely ordained, and human rights are compatible only if they do not challenge Islamic law. In other words, that certain rights meaning that they need to be adjusted, reinterpreted, or even canceled to align with Sharia law. There is the reformist view or perspective that Sharia law can be interpreted in ways that more compatible with human rights and revolves around what we call the Sharia essentials, or the Sharia maqasid, or the objectives, which mostly focuses on the welfare of the community or the common good of the community, which is very important, of course, when it comes to that. And you will see that there are the traditional interpretation of Islamic law and the international human rights issues come within that, a perplexing idea when it comes to freedom of religion, gender equality, minorities' rights, and non-discrimination rights, or privacy, protection from torture. And the two main examples here that when it comes to highlighting these challenges, specifically in reconciling certain interpretations of Islamic law with the universal human rights standards, you will see Saudi Arabia and Iran. So it is very important here when it comes to the existing frameworks in the Middle East that faces different challenges when it comes to political manipulation. How many countries have experienced that kind of political manipulation of TJ measures, highlighting the limits of such mechanisms. Weak states, when it comes to the state, try often to play a key role in implementing transitional justice measures. However, in some countries or failed states, as we see, for example, right now in Libya or Yemen or other places, that it is very weak and there is no robust system of the rule of law. Lack of trust, as I mentioned before, and of course, exclusion of religion to some extent. And you'll see that it's diversified from country to another when it comes to the Constitution and the interpretation of the Constitution as well. There are a lot of case studies actually in the Middle East, and I think I will invite all of you if you can check them out, specifically after the Arab Spring events that took place since 2011. You will see recently, I think Syria is a great case study to cite that transitional justice faces major obstacles due to the scale of violations that have been committed under the Assad regime. So the systemic abuses perpetrated over decades. And I think crafting TJ mechanisms must address promoting reconciliation in a deeply divided society at this point. Also, Iraq had the same things when it comes to the intertwining TJ with broader transitional justice processes when it comes to judiciary, security sectors, and of course, economic reforms are crucial. Same in Iraq, same in Libya, that you will see that there are a lot of fragmentation within a civil war and militias, and that Tunisia had the same thing, and the failure of Tunisia to address economic concerns, that's for sure, undermined stability and the political progress that Tunisia had been achieved earlier within the Arab Spring events. Egypt as well canceled the Ministry of Transitional Justice that had been created after the revolutions, and that's of course represent a step back and a step within the rule of law, meaning that the regime doesn't really care about the victims and their families for the abuses that have been committed under either the Mubarak regimes in Egypt or the Muslim Brotherhood regimes as well. So you will see that there are cultural and religious barriers to some extent when it comes to transitional justice. Um, Cultural relevance at some point, the religious perspectives when it comes to the concept of forgiveness, restitution, and reconciliation, legitimacy issues. Also, these risk losing legitimacy if they fail to align with cultural and religious values, leading to resistance and undermining reconciliation efforts. So I guess this is kind of also important to address, because when it comes to these concept of religious challenges for transitional justice, for example, I said that the mechanisms are also criminal prosecution when it comes, even in Islamic law, when it comes to the categories of crimes like hudud, qisas, ta'zir, like retribution or discretionary punishment, or when it comes to reconciliation, like truth commissions, compensation, repentance, or forgiveness. Or if you have the hybrid approach, which means that we do have the elements of criminal prosecution and reconciliation and its preferred option to avoid culture of impunity. And I think that will, of course, envisions the concept of individual responsibility or self-accountability, which mostly important, very important when it comes to what we call, or when it comes to what we have talking about the reconciliation within the religious approach. Because to reconcile, meaning that to make peace, to have an agreement between the two parties that they are in conflict, to facilitate the process of settling the disputes, and of course, acknowledgement of the committed crimes, meaning the acknowledgement of the legal accountability and that the confession have been committed by the aggressor, and I mean the declaration of the responsibility itself, which is very significant and very important for that. There will going to be kind of some resistance from various stakeholders when it comes to the stakeholders, the resistance from when it comes to like transitional justice effort at some point will face these challenges from non-state actors, like, or from politicians, or we call them elites, that they are in office. And here they're going to be the victim participation barriers when it comes to security concerns, resource shortages, political barriers, as I mentioned before, the political manipulations, and that have been represented a lot in the MENA region, the Middle Eastern region, government divisions when it comes to the internal conflicts within the government, and there is no like kind of unity when it comes to the government institutions, and there is no like a kind of a roadmap to achieve how the rule of law should be established or should be implemented. Reparations and reparation programs and restorative justice will be very interesting also to discuss and to realize, because that's, as I mentioned, the victims in specifically in the Islamic jurisprudence or the religious approach will have different options when it comes to restore the rights. For example, if they want to prosecute the offender and retain the original penalty or punishment. However, victims are also offered the options of compensation, conciliation, or pardon. And pardon here is totally being considered the most elevated choice, and pardon mostly recognized as a fundamental principle concerning various tensions and cases of injustice. There is a kind of discretion, of course, when you are applying the pardon. And now we do have that, and only the president of a country will have this authority according to the Constitution, including the Constitution of the United States, that the president have the authority to pardon or to commute legal sentences for specific groups based on, of course, their criminal records and other factors may be considered. Compensation, it's a key aspect of reparations, financial compensation, either in religious laws or in positive laws for the victims and their families in cases of murder, injury, property damage. State role, which is important. If an offender is unable to provide compensation, the state should step in to ensure that this victim is compensated. Restitution, meaning like that you have compensation in cases of offenses targeting property or torts or civil wrongs. So I think there are a kind of diversified measures when it comes to reparations, which also acknowledge how transitional justice is kind of important when it comes even to the reparation initiatives. Like criminal law is important when it comes to pardon, compensation, restitution when it comes to offenses against property or torts, individual cases for sure, if any kind of personal injury or death might happen. And there is kind of flexibility when it comes, of course, to the interpretation of each case by case basis, of course, depending on the severity or the gravity of the crime or damage, of course, the personal and social status of the offender. So it is important to also see that there is kind of a kind of what we call the bottom-up approach and top-down approach or down-top approach when it comes to incapacitation, deterrence, and capacity building, and how all these are playing a kind of significant role when it comes to who is a rational actor, who is a citizen, and how the citizen will be able to identify all of these significant elements when it comes to that. Of course, it is important to make sure that promoting reconciliation through transitional justice is very important. As we saw, for example, in South Africa, that was an important case. It's important for future approaches, I think, for the Middle East to make sure about preparations and to build inclusive, peaceful societies down there. I guess it is very important to make sure that transitional justice addresses human rights violations through judicial redress, political reform, cultural healing to prevent future abuses. Systemic racism remains a challenge, necessitating principles of equality and justice, including those found even in religious laws. It is very important to make sure that truth commissions, reparations, and restorative justice within the religious and positive legal framework can help address grievances and promote reconciliation. Moving forward, context-sensitive reforms that incorporate religious principles, specifically Islamic principles, will be key to build inclusive societies and ensuring equitable outcomes. I gotta tell you also that I wanted to finish and conclude with the cases here, like of Egypt, specifically when it comes to after the stepping down of the Mubarak regime. How was Egyptian looking at transitional justice? And instead of focusing on the perpetrators of human rights violations, there have been a kind of guilty by association. So by again failing to distinguish between justice and collective retribution, the same mistake is being repeated when it comes to that. And I guess it has been important because I think when it comes to make sure what is the key issue in which to focus now is how the ministry can begin to achieve transitional justice, or the regime that it have to make sure that we have this kind of ministry or agency to be independent from the government and have to be impartial, specifically when it comes to restructuring and reforming institutions, investigating crimes under the regimes that have been committed. Those otherwise, transitional justice process will become selective or retaliatory justice. If you look, for example, at I think poor governance, of course, will be kind of represent a kind of an obstacle for that. The general absence of the rule of law and the human rights deficit within that for this. I guess it's important to make sure that, for example, Article 241 of the Egyptian Constitution after the revolution have been enhancing and talking about transitional justice as an example, and said like to ensure or ensures revealing the truth, accountability, proposing frameworks for national reconciliation and compensating victims in accordance with international standards. So I think the suggested or solution or moving forward here is to establish a kind of higher commissioner and should make an effort to educate and involve the citizen in transitional justice, collective evidence, hold hearings, drafting guiding laws, draw a roadmap, and set a clear agenda for that, and making sure that there is a kind of addressing issues when it comes to like pressing TJ measures, providing suitable protection for witnesses and families of the victims, and all that. I think it is very important when it comes to this. And I would like to end my comments and my remarks today with this quote: to achieve reconciliation through transitional justice, those currently in power should at least begin to remove the most significant obstacles to transitional justice. So that's it for the keynote for this conference. Once again, I am very honored and privileged by the invite. I'm very thankful to the organizing committee for having me on board and for giving this keynote for my upcoming book to the audience. I look forward, of course, to your questions and your feedback. And once again, please join us in November for the International Conference on International Law and Legal Theory. Once again, thank you very much, and have a great day and have a great conference. Thank you.